What you know, alibiyers? Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Tuesday, October 7th. You guys are going to have to excuse my voice. I have had a cold for the last few days, but I really wanted to get this episode in today and early because I tend to lose my voice after about lunchtime. So what's going on in the world of Kouri Richins? Well, a lot right now, including one of the main witnesses for the state flipping his story and saying that he never sold the housekeeper, Carmen Lauber, fentanyl. And he gave two different affidavits on September 10th about this. So let's jump in. It says, "My name is Robert Crozier, and I'm currently residing in the Davis County Jail. I'm over the age of 18 and have personal knowledge of all facts stated herein unless otherwise so stated. I've been identified as a witness in the above stated manner. In that capacity, I've been interviewed on two separate occasions by individuals associated with the prosecution of Kouri Richins. I've been told that the first interview was on or about May 4th, 2023. It was conducted by two officers from the Summit County Police Department at the Davis County Jail. I've been told that the first interview was on or about May 4th, 2023. It was conducted by two officers from the Summit County Police Department at the Davis County Jail. I do not know the names of the officers who interviewed me. On May 4th, 2023, I'd been in jail for a short time and was detoxing from drug use. I do not have any personal recollection of the details of that interview, although I've since been told that I agreed I had sold fentanyl to Carmen Lauber in 2022 on two occasions. In early April 2025, I was asked to meet with two people from the Summit County Attorney's Office. I believe that both individuals were prosecutors, and they told me they were prosecuting Kouri Richins. I believe that one of them was Brad Bloodworth. I cannot recall the name of the other individual who was at the meeting, but it was a man with a beard. I was sober at that meeting and had been sober for over 3 months. We met at Starbucks Coffee in downtown Salt Lake City. Mr. Bloodworth and the other individual asked me if I had sold fentanyl to Carmen Lauber. I told them no. I sold oxycodone to Carmen Lauber on two occasions in early 2022. I told them I met her at the Maverick in Draper, both times to sell her the pills. They asked why I had previously told officers that I had sold her fentanyl. I told them I did not remember saying that and that I had been detoxing during the interview and was out of it. I told them I was certain that I had sold Carmen Lauber oxycodone 30 milligram pills, otherwise known as Roxy's or Roxy 30s. They asked me several times if I was sure, and I told them yes. I was sure I sold her oxycodone. I was told at that meeting that I would be called as a witness in this case, and the Summit County Attorney's Office would be putting me up in a hotel near the courthouse. I certify that this statement is true, and again, this is dated September 10th of this year. The same day, there was another affidavit that was submitted by him, so let's read through that one. In early 2022, I was contacted by my friend Nicole Cummings telling me that a friend of hers by the name of Carmen Lauber was looking for some pills and would be contacting me. Soon after, I received messages from Carmen Lauber asking to purchase some pills. On at least one occasion, she told me she wanted Roxy 30s, and on at least one other occasion, she said she wanted blues. I understood this to mean she wanted 30 milligram oxycontin pills. In early 2022, I knew the term blues to mean oxycontin. I did not associate the term blues with fentanyl until late 2022. I met with Carmen on two occasions in February 2022 at the Maverick in Draper and sold her oxycontin. The first time I sold her 30 pills. The second time I sold her more than 30 pills, but I can't recall how many. These were the only two times I met Carmen. I did not know her before she contacted me, and I have not had contact with her since February 2022. I began selling fentanyl at the end of 2022. In May 2023, I was arrested for possessing fentanyl and was in Davis County Jail. At that time, two officers from the Summit County Police Department interviewed me. I do not remember their names. I was very confused during this interview as I was detoxing from drug use and was very out of it. At first, I did not remember Carmen, but after they reminded me, I did remember that I had sold pills to her and that she was a friend of Nicole Cummings. I don't remember the details of that interview, but I've since been told that during that interview, I agreed that I'd sold fentanyl to Carmen Lauber and that blues refer to fentanyl. It is my belief that I agreed I'd sold Carmen fentanyl because I was personally detoxing from fentanyl during that interview. And by then, I had been selling fentanyl, which I had come to know as blues. I am currently in recovery, and although I relapsed during my recovery, at this time I've been sober for about 3 weeks. Prior to my relapse, I had been clean for 9 months. I did not sell Carmen fentanyl in February 2022, but sold her 30 milligram oxycodone pills. In early 2022, I was not selling fentanyl and I did not have access to fentanyl. Rather, I was selling my own oxycodone prescription, which were 10 milligram pills. If a buyer wanted stronger pills, I had a source who provided 30 milligram oxycodone, which is what I sold to Carmen. Roxy's or Roxy 30s refer to 30 milligram oxycodone pills. To my knowledge, blues also referred to oxycodone until late 2022, when I came to know the term is also being used for fentanyl. I did not acquire a source for fentanyl until the end of 2022. The fentanyl pills that I began selling at that time were very dark blue, almost purple. In April 2025, I was interviewed by prosecutors with the Summit County Attorney's Office and told them that I'd sold oxycodone to Carmen and not fentanyl. And then the last part says, I certified the statement is true. The next motion that was filed was a motion to appoint counsel for witnesses. And it says the state has provided in discovery the statements of several potential witnesses relating to their participation in the alleged unlawful distribution of controlled substances. These witnesses have also been identified as likely witnesses at trial due to their inclusion at the state's request in the jury questionnaire. To date, the defense is only aware of one of these witnesses being granted any sort of immunity. The remaining witnesses face potential state and or federal criminal liability if they take the witness stand at trial and testify consistently with their statements produced during discovery. In order to protect their liberty interests, these witnesses should be appointed counsel to advise them of their Fifth Amendment rights. Defense counsel are not in a position to do so due to their conflicts of interest. It is important for these witnesses to be appointed counsel prior to trial in light of the Utah Supreme Court's ruling that a lawyer conducts himself unprofessionally when, for the purpose of impressing upon the jury the fact of the claim of privilege, he calls a witness to testify when he knows the witness will claim a valid privilege not to testify, and they cite State v. Travis. Without the assistance of independent defense counsel advising these witnesses, there is no way for defense counsel to avoid this trap. Furthermore, defense counsel may be entitled to assert unavailability of the witnesses if they have advanced knowledge of the witness's intent to assert their Fifth Amendment right and can then subpoena the witness to appear before the trial judge to assert said right. And they cite State v. White. An unavailability determination may lead to pretrial admission of otherwise inadmissible hearsay critical to the case. Appointing counsel prior to that procedure will serve the best interests of judicial economy by avoiding having to come back for a second appearance after the appointment of counsel and an opportunity for counsel to consult with the witnesses. The particular witnesses at issue include, but may not be limited to, Nick Bonsavage, Susan Kohler, Robert Crozier, Nicole Cummings, and Sheila Peterson. They end it with the defense respectfully moves this honorable court to appoint independent defense counsel to advise the 5 witnesses listed above that their Fifth Amendment rights with respect to any testimony about their alleged participation in criminal activity. That was submitted by Catherine Nestor, one of Kouri's attorneys. And of course, the next motion is a motion to reconsider bail and conditions of release. This was filed October 2nd. It says Eric Richins, by and through undersigned counsel, hereby moves this court to reconsider setting bail and ordering conditions of release pursuant to Utah Code, which provides in part that a party may move to modify a pretrial status order at any time upon showing that there has been a material change in circumstances. This motion is based on the following. The first section is history of proceedings. The matter of bail has been brought before this court on 2 occasions. First, on June 12, 2023, this court conducted a detention hearing and considered exhibits, testimony, and arguments submitted by the parties. At that time, Ms. Richards was facing a potential death penalty on the aggravated murder charge and was not entitled to bail as a matter of right pursuant to Utah Code. The court did, however, go on to find that there was substantial evidence to support the charge and clear and convincing evidence that the defendant would pose a substantial danger to the community if released on bail. At that time, the court made no findings of risk of flight. On October 22, 2024, Ms. Richins, through counsel, filed a motion to reconsider bail, arguing that there had been a material change of circumstances since the prior detention hearing. The court found that a material change in circumstances did exist, and on November 12, 2024, a hearing was held on the motion. After the oral argument, the court ruled from the bench that there was still substantial evidence to support the charge and clear and convincing evidence that the defendant would pose a substantial danger to the community and further was a flight risk. Ms. Richins has now been held in pretrial custody for 28 months. The next section, material change in circumstances since November of 2024 hearing. The following circumstances have changed since the previous detention hearing and call for a renewed review of bail and/or conditions of release in this case. Number 1, new evidence has come to light that goes to the heart of the state's allegations that Ms. Richins poisoned her husband with fentanyl. The state's case is based on statements made by Carmen Lauber that she procured fentanyl from Mr. Robert Crozier on 2 occasions and sold it to Ms. Richins. The defense has recently learned that in April 2025, Mr. Crozier met with prosecutors for Summit County and informed them that this was not true. Mr. Crozier told members of the prosecution team that he did not sell fentanyl to Ms. Lauber, but rather sold her oxycodone. In a footnote, it says this statement is also consistent with Ms. Lauber's original statement that she sold only oxycontin to Ms. Richins. Although the state failed to disclose this exculpatory statement to the defense as required under Brady and Giglio, the defense learned of it independently when they interviewed Mr. Crozier on September 3, 2025, at which time he relayed this exculpatory information. Number 2. Mr. Crozier has now informed both the state and the defense that he sold only oxycontin to Ms. Lauber on 2 occasions in early 2022. And it says, see attached affidavit of Robert Crozier. He further told both the state and the defense that he did not recall previously telling Summit County detectives that he had sold fentanyl to Ms. Lauber. And at the time of the previous interview, he had been detoxing and was out of it. Mr. Crozier, who is now sober, states that he is certain that he sold Ms. Lauber 30 milligram OxyContin pills on both occasions. Moving on to the argument. Utah Code provides that 1, an individual charged with or arrested for a criminal offense shall be admitted to bail as a matter of right, except if the individual is charged with a felony where there is substantial evidence to support the charge and the court finds by clear and convincing evidence that the individual would constitute a substantial danger to any other individual or to the community after considering conditions of release that the court may impose if the individual is released on bail, or the individual is likely to flee the jurisdiction of the court if the individual is released on bail. Although the court has previously found that there is substantial evidence to support the charges against Ms. Richins, Mr. Crozier's recanting of his previous statement changes the landscape to a degree that cannot be ignored. In order to continue to hold Ms. Richins without bail, the court must first find that there is substantial evidence to support the charge, and that simply no longer exists. Our Supreme Court has explained that the purpose of the substantial evidence standard in the bail context is to ensure that the quantum of evidence presented by the state sufficiently justifies the denial of the defendant's right to freedom from pretrial incarceration. In this matter, the state's entire theory of criminal liability is that Kouri procured fentanyl from her housekeeper, Carmen Lauber, which she caused to be unwillingly ingested by her husband in some unknown way, directly causing his death. There is no physical evidence of this, but only the statements of Carmen Lauber, and these statements are wholly dependent on whether or not Lauber procured fentanyl from Robert Crozier. None of these so-called fentanyl pills were found nor tested. Lauber only believes she sold Kouri fentanyl because she believed that is what Crozier gave her. There's a footnote here that says Carmen Lauber's original statement was that she never sold fentanyl to Miss Richins and that Miss Richins never asked her for fentanyl. Only later did she change her story to say that she did get fentanyl from Crozier and then gave it to Kouri. If Robert Crozier did not, in fact, sell fentanyl to Lauber, there can be no credible argument that substantial evidence of guilt exists. And since in criminal cases, a jury must find a defendant guilty beyond a reasonable doubt, the substantial evidence standard is met when the prosecution presents evidence capable of supporting a jury finding that the defendant is guilty beyond a reasonable doubt. Even though the prosecution's cases need not be airtight, and the defense must do more than have poked holes in the state's case, there must be evidence that supports the element of the crime charged. That is not the situation before this court. If the state could not place fentanyl in the hands of the defendant, the state has no case. Mr. Crozier's statement doesn't just poke holes in their case. It throws a grenade into the middle of it, leaving them with nothing but speculation and conjecture, getting them nowhere near the realm of beyond a reasonable doubt. It says, see also Randolph versus State of Utah. A district court may not deny a defendant bail unless the facts adduced by the state, notwithstanding contradiction of them by defense proof, warrant the conclusion that if believed by a jury, they furnish a reasonable basis for a verdict of guilt. And they cite Chenoweth versus Larson. Without substantial evidence to support the charge of aggravated homicide or attempted aggravated homicide, the analysis ends and Ms. Richins should be released. For the reasons stated herein, Ms. Richins respectfully moves this honorable court to reconsider its previous detention ruling and grant her the privilege of pretrial release. And the last filing is from October 2nd as well. It is a request for order compelling disclosure of exculpatory evidence. It says prosecutors say she mixed a lethal dose of fentanyl into his drink. They link in the footnotes a couple of different articles. Kouri Richins' housekeeper allegedly sold her fentanyl pills prior to her husband's poisoning. And in the footnotes, there is a link to a YouTube channel. And that link goes to Law and Crime Trials YouTube page from the preliminary hearing that Kouri had. Kouri Richins, the Utah mom who allegedly poisoned her husband with a fentanyl-laced cocktail. In the footnotes, there's links to these articles. Prosecutors allege she gave Eric Richins a lethal dose of fentanyl on the night of his death. Eric's family suspects she placed the fentanyl in that Moscow mule. Investigators now say a woman accused of fatally poisoning her husband asked multiple people if they could procure fentanyl for her. Prosecutors previously have said she acquired fentanyl through a woman who cleaned houses for her business, both in the months before and shortly after her husband's death in March of 2022. A search warrant granted earlier this month, however, indicates investigators believe the woman was not the only person Richins went to for fentanyl. All these headlines stem from the allegations that Ms. Richins procured oxycodone and ultimately fentanyl from her relationships and connections with Carmen Lauber, Robert Crozier, Nick Bonsavage, and Susan Kohler. Initially, Ms. Lauber informed investigators that fentanyl was never procured. And it says, see transcript of Carmen Lauber interview from April 27th, 2023. The investigating officer subsequently interviewed Ms. Lauber again on May 3rd, 2023. It was at that meeting when Ms. Lauber indicated she got fentanyl from Robbie, otherwise known as Robert Crozier. See transcript of Carmen Lauber interview May 3rd, 2023. Mr. Crozier was interviewed in May 2023. During his interview, he confirmed he had sold fentanyl to Ms. Lauber on 2 occasions. Sometime in April of this year, Mr. Crozier was interviewed by 2 members of the Summit County prosecution team at a Starbucks in Salt Lake City. The prosecution team asked if he had sold fentanyl to Ms. Lauber. He told them he had not sold fentanyl. He specified he had sold oxycodone to Ms. Lauber on 2 occasions in early 2022. He told the prosecution team he met Ms. Lauber at the Maverick in Draper, both times to sell her the pills. The prosecution team asked why Mr. Crozier had previously stated he had sold Ms. Lauber fentanyl. He specified he did not remember saying that he had sold fentanyl and told them he had been detoxing during that interview and was out of it. He told the prosecution team he was certain he sold Ms. Lauber oxycodone 30 milligram pills, also known as Roxy's or Roxy 30s. The prosecution team asked him several times if he was sure, and he told them he was sure he sold Ms. Lauber oxycodone. The prosecution has been aware of this exculpatory evidence since April of this year. They did not inform the defense of this information. No press release was issued, no reports, nothing. The prosecution just kept quiet. In preparation for trial, defense counsel located and interviewed Robert within the past 30 days. It was during this interview that the meeting and the exculpatory information became known to defense counsel. There's a footnote that says defense looked within discovery folder provided by the prosecution after the discovery of this information and prior to the filing of this request and could not find anything related to this interview. The prosecution is required to disclose to the defendant the following material or information directly related to the case which the prosecution team has knowledge and control. Evidence that must be disclosed under U.S. and Utah constitutions, including all evidence favorable to the defendant that is material to guilt or punishment. Their duty to disclose is a continuing duty as the material or information becomes known to the prosecutor. Rule 3.8 of the Utah Rules of Professional Conduct prescribes duties specific to the unique role of a prosecutor. It requires a prosecutor in a criminal case to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. The timelessness of a prosecutor's disclosure of exculpatory evidence is a matter governed in Utah by our rules of criminal procedure. By rule, a prosecutor must make all disclosures as soon as practicable following the filing of charges and before the defendant is required to plead. The court highlighted the distinction between the procedural rule and its ethical counterpart. The requirement of timely disclosure is important. It is aimed at allowing the defendant to adequately prepare his defense, and our ethics rule has the same evident focus. Rule 3.8D of the Utah Rules of Professional Conduct requires more than just disclosure. It requires a timely disclosure. This distinction is critical because without its ethical counterpart, a prosecutor would rarely face a consequence because it could hide behind the wide latitude and continuing obligation provided by Rule 16. If the prosecutor's possession of exculpatory evidence is uncovered at trial, a subsequent admission of that fact may be somewhat mitigating at the sanction phase. But the admission is not itself a fulfillment of the Rule 3.8D duty of disclosure. If that were enough, the rule would be rendered practically toothless, as any savvy prosecutor could avoid an ethics violation by a simple expedient of an after-the-fact admission of a prior failure of disclosure once it is exposed by someone else. A prosecutor cannot conflate the Brady standard with the prosecutor's ethical duty under Rule 3.8D. The two standards are distinct. The question under Brady is a matter of due process of whether the prosecution's failure to disclose exculpatory material so undermines our confidence in the verdict that we should order a new trial. But Rule 3.8D's disclosure is different. It is aimed not only at assuring a fair trial by articulating a standard for a motion for a new one, but also at establishing an ethical duty that will avoid the problem in the first place. In stating that duty, our rule requires timely disclosure by the prosecution. That duty cannot be fulfilled by a prosecutor's mere admission of the existence of exculpatory evidence made after a witness first uncovers it. In addition to the timeliness of disclosure, the prosecution's state of mind relating to the disclosure is paramount in determining an appropriate sanction. Here, the prosecution failed to disclose evidence that not only negates Ms. Richins' guilt, but completely eviscerates the prosecution's own theory that Ms. Richins procured the fentanyl that ultimately killed her husband. The prosecution's failure to disclose and continued concealment of exculpatory evidence that Ms. Richins did not procure fentanyl inflicts ongoing harm on Ms. Richins, the public, and the integrity of our legal system. This is precisely the type of misconduct Rule 3.8 was designed to prevent. By withholding this evidence, the prosecution abandons its duty to seek justice and undermines the assurance of a fair trial. No doubt there will be an attempt to chalk this up to an oversight, perhaps as an oversight that should be excused as nothing more than carelessness. But this was not an oversight. This was a continuing and knowing concealment. It is not a blemish on the fruit. It is rot at the core, poisoning the whole harvest of justice. The next section, it says, covenants without the sword are but words. And that's Thomas Hobbes. Courts have long trusted the prosecution to discharge its duty without supervision. But when that trust is broken, when evidence negating guilt is withheld, trust alone no longer suffices. In this case, words like timely and becomes known suddenly demand a deadline. Counsel moves this court for a standing order imposing a 3-day deadline on the prosecution to disclose the following to the defense. Number 1, all evidence, including emails, text messages, phone messages, recordings, video footage, or any other form of correspondence involving the prosecution teams or any law enforcement official and Robert Crozier, including correspondence about setting up a meeting and any sort of summaries of the meeting. Number 2, all notes, correspondence, or reports prepared by law enforcement officials or any member of the prosecution team discussing Robert's interview in April and or any other dates. Number 3, any statements, recordings, reports, or notes in whatever medium, including emails and texts that tend to negate guilt. Furthermore, the defense respectfully requests this court require the prosecution to disclose on the record or to reduce to writing and provide to the defense all oral statements delivered when interviewing witnesses that tend to negate guilt or contradict prior statements made by the witnesses. And that was dated just October 2nd. My opinion is that I don't think this affects her getting out on bail. I mean, at the end of the day, she is still charged with the murder of Eric Richins. I think the bigger issue is going to be whether or not it's proven that the state withheld exculpatory information from the defense, which could have professional ramifications for the prosecution, and it could affect things not coming in at trial. As far as the drug dealer recanting his statement and going in the opposite direction, it's going to come down to who the jury finds the most credible, the drug dealer or the housekeeper, Carmen Lauber. Just my opinion on all this. It'll be very interesting to see how this plays out. Whenever there is an update on any of these issues, I will bring it to you as soon as I can. But that is it for today. I hope you guys have a good rest of your afternoon, and we will see you soon.